Our 28th Amendment. What should it be? With approximately 12,000 proposed amendments since the Constitution was ratified in 1789 and a large number of pressing issues in our nation, this is a difficult question to answer. However, due to the Supreme Court's recent overturning of Roe v. Wade in June of 2022, access to abortion is under increased threat in the United States, now that abortion is no longer federally protected. To guarantee citizens their right to liberty, which is essentially an individual's freedom from unreasonable restrictions, a reproductive rights amendment must be added to the Constitution of the United States. The Reproductive Rights Amendment would explicitly state a pregnant person's right to an abortion until fetal viability, which is medically defined as a fetus's ability to survive outside of the womb, and typically occurs around 24 weeks gestational age. Although according to the National Library of Medicine, only 1% of abortions take place at or past 21 weeks, this amendment would still allow states to protect abortion past the point of viability if deemed necessary by patient and physician. A reproductive rights amendment is imperative in securing the right to abortion for women nationwide, as it would explicitly set abortion as a constitutional right. This would put an end to the decades of debate over whether or not the 14th and 5th Amendment protect abortion, such as in 1970, when the Supreme Court was faced with a legal case between the plaintiff, Norma McCorvey, who had protected her identity with the alias Jane Roe, and Henry Wade, the district attorney of Dallas County in Texas. Roe, a single pregnant woman, demanded federal action against the Texas criminal abortion laws. In 1973, the Supreme Court ruled that unjustified state restrictions on first trimester abortion were unconstitutional. In 2022, the Supreme Court's 5-4 decision in Dobbs v. Jackson Women's Health Organization overruled two historic abortion cases, Roe v. Wade and Planned Parenthood v. Casey, which means that a pregnant person's right to an abortion is no longer constitutional. States can now set their own restrictions on abortion without acknowledging the guidelines that these two cases set in the 20th century. Although abortion is not an enumerated right in the Constitution, the first section of the 14th Amendment states that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of the law. This section of the 14th Amendment allows for the use of substantive due process to protect unenumerated laws, such as abortion. Substantive due process is the idea that not only the procedures of a law must be fair, but also its content. This brings us to the second reason why the Reproductive Rights Amendment is needed, which is, to put it simply, abortion bans and restrictions are unfair for those seeking abortion. According to the UC San Francisco Medical Center, 1 in 3 women discover their pregnancy after 6 weeks gestational age, and this discovery is more likely to occur in younger people and people of color. Thus, the new abortion bans that set a gestational limit, some of which go as early as 6 weeks, have a disproportionate, harmful effect on these groups who already face discrimination in healthcare. The Turnaway study conducted by UC San Francisco on the long-term effects of abortion denial showed that women who had to complete an unwanted pregnancy were more likely to experience physical and mental health complications. Although abortion can be a difficult choice to make, there is no evidence, however, that the procedure itself negatively affects a woman's mental health. Abortion is also physically safe, as less than 0.25% of women experience health complications after the procedure, which is safer than getting your wisdom tooth removed. So, how is it fair for states to make laws restricting a woman's private bodily choice, specifically a choice involving a procedure with no proven negative effects on the patient? Our nation's current abortion laws and restrictions still follow the American Medical Association's anti-abortion doctrine from the 19th century, which was created to criminalize the unlicensed female abortionists who dominated the abortion field at the time, so that white male licensed physicians, who are not at all representative of those seeking an abortion in our nation, could gain leverage in the healthcare market. These men demonized abortion as a business strategy, even though the procedure was actually very common at the time. To successfully protect a pregnant person's right to choose, the Reproductive Rights Amendment should be proposed by the Senate and House of Representatives and passed in a 2/3 majority vote. Once adopted by Congress, the Reproductive Rights Amendment would hopefully go on to be ratified by 3/4 of the states. I am grateful that my home state protects abortion, but I watch, devastated, as others continue to place unjustified, discriminatory guidelines on the bodies of their residents. It is time for our nation to protect the right to abortion in its Constitution. The Reproductive Rights Amendment will guarantee that in our land of the free, people can make the healthcare choice that is best for them, whether or not that includes receiving an abortion.